at Chicago Volunteer Legal Services. So I am the least important person on this call. Mostly try to provide support to the NIJC. So I'm a guardianship attorney for kids. I'm not an immigration attorney, but as we all know, the SIJ cases kind of hit in both realms. So trying to provide more support to Hillary and the NIJC and help disseminate information about guardianship, and also CVLS provides pro bono attorneys to do the state court portion of these cases.
Hi everyone, I'm Hillary Richardson. I'm a supervising attorney at the National Immigrant Justice Center. And I focus my work on unaccompanied immigrant children and kids who are otherwise particularly vulnerable. And I also run our SIJS Predicate Order pro bono program. So Rebecca, as she said, and CVLS have been amazing partners in that process, as well as some other organizations, including Catholic Charities, who I think is on this call as well, and a whole slew of private attorneys who've really stepped up to try to help us with these unusual cases in state court as we move forward trying to get protection for these kids. So we'll go through the process and just explain a little bit more about what we're talking about and what it would involve to get a predicate order, what that means, and how your organizations might be able to get involved and provide services to kids in this position. Because I think we are seeing that it is something that more people are becoming more aware of, and we're seeing definitely more kids who are eligible for this. So we're here to I think I speak for CVLS and NIJC. We're here to be resources and really hope that everybody can be as educated as possible about this process so that more vulnerable kids are able to get representation. So that being said, let's see if I can click through this. All right, we are going to resume the slideshow. So our presentation today is going to be broken down into a couple of sections. So the first part is going to be just talking about what Special Immigrant Juvenile Status is, what it looks like, what the statute says, how you get it. And then we'll talk briefly about a new law as of the beginning of this year in the state of Illinois that really expands protections for kids who are eligible for SIJS. And then we'll talk about getting an SIJS predicate order in a state court in Illinois. We'll take a little break, and then we'll go through the process for immigration petitions for kids who are eligible for SIJS, and then we'll have some time for some Q&A at the end. Rebecca, what do you think about having people ask questions? Like, do you think, as far as preference, should we have them chat? Should we have them just jump in?
How many people are on the call? I can't see that information.
52.
Oh, wow.
Yeah.
If somebody is monitoring the chat, that might work best. But I don't know whether Jane, is someone monitoring the chat and able to interrupt with any questions that come through?
Oh yeah, that would be really
I'm monitoring the chat.
That would probably be ideal, no?
Yeah, that's perfect.
Okay.
Cool, thanks Jane. Okay, and then just a brief note, we are focusing right now on Illinois because SIJS is a combination of immigration law and state law, but we are aware that, for example, the Chicago Immigration Court has jurisdiction over residents of Illinois and Indiana and Wisconsin. If you have questions about a case in Indiana or Wisconsin, you're welcome to reach out to me separately. We have some resources there. I'm not licensed in either of those states, but NIJC does place some cases in those states. And so we have some information, not a ton at the same level of expertise and resources that we have for Illinois. But today we'll be focused on SIJS as it pertains to kids living in Illinois.
And that will also be true for the state court information. So I'm mostly going to I'm going to focus on SIJS in probate or guardianship cases, but we'll also talk about how to get them in domestic relations. And again, all of those are state law only. So the domestic relations laws and guardianship laws and requirements may be different from states.
Exactly. Okay, so let's see if I can. Oh, I did it again. Okay, reason slideshow. Still working on Zoom expertise, you guys. Here we go. SIJS. Here we go. Okay, so I'm going to talk a little bit about an overview of the SIJS statute. So, Special Immigrant Juvenile Status is an immigration benefit. It's a form of immigration relief to kids who have been abused, abandoned, or neglected by one or both of their parents. The child has to be living in the United States. This isn't something you can apply for from abroad. And it's great because if granted, it puts the child on a path to citizenship. You can apply for a green card and then eventually apply to become a citizen. A very important point that we always go over with our clients before even starting this process is that a child granted special immigrant juvenile status, no matter where they are in the process, so even after they become a U.S. citizen, they can never petition for either of their parents. Even if one of their parents was abusive and one was not, neither parent can ever benefit from that child's immigration status in the future. So these are, I think, helpful resources that you all are welcome to go back to. I'm not going to read through all of the federal laws and regulations and USCIS guidance, but I think as with all immigration law, there's so many different legal resources. It's a good place to start if you're going to start a case. So you would go to the INA. The definition, which we will go over, is at 101E27J. And then there's other applicable laws that would apply throughout the process that you would want to look into. So the statutory requirements for a child to be eligible for special immigrant juvenile status are that the child be under 21 years of age and unmarried. That's a child per the immigration law. They have to be present in the United States. And then a juvenile court has to have declared the child dependent on the court or place them under someone's custody. So that can be the custody of a state agency, or it can be the custody of an individual. The juvenile court has to have made a determination that the child's reunification with one or both parents is not viable due to abuse, neglect, abandonment, or a similar basis under state law. The state has to determine, the juvenile court has to determine it would not be in the child's best interest to return to their home country. And then, I'm gonna go back. Can I go back? There we go. The Secretary of Homeland Security consents to the grant. That just means you apply and USCIS approves it. So what do these requirements mean? So we're going to get into that a little bit. A juvenile court is the first piece that we're looking at for that little three-part section. A juvenile court under the INA means any court with jurisdiction under state law to make judicial determinations about the custody and care of juveniles. So that means for Illinois' purposes, this can mean domestic relations and parentage cases. It can mean guardianship cases. It can be adoption. And then it also includes child welfare, abuse and neglect cases, and juvenile delinquency cases. And what all of these types of cases have in common is that a court is making decisions about children, and that court has the authority to make a custody determination about children, right? So guardianship is a form of custody, adoption is a form of custody, a juvenile delinquency case where the state sentences a child to a certain sentence, right? If you are sentenced to juvenile detention, that's custody of the state. So all of these cases control child custody, so all of these courts are able to make these determinations. An important point here, which we can talk about a little bit more, is, do you remember in the statute, it said that a child has to be under the age of 21, but what's the age of majority in Illinois? That's right, 18. I'm glad you all called it out. The age of majority in Illinois is 18. That means anyone in Illinois over the age of 18 is an adult. That means that a juvenile court will no longer have custody over 18 to 21-year-olds. This means that these state court orders right now in Illinois have to be entered before the child turns 18. And we'll talk a little bit about kind of timelines for that. We do end up seeing a lot of 17-and-a-half-year-olds that come to us. Sometimes we're able to get those orders based on emergencies, and sometimes we're not. So that's the cutoff date we're looking for. One exception to that can be in juvenile delinquency cases and certain child welfare cases. Those courts, if they take jurisdiction of the child before they turn 18, may then be able to extend that jurisdiction to 21. But because those courts are also, that's a much more state agency involved case, right? DCFS controls the child welfare case. The state's attorney is the one who proceeds with the juvenile delinquency case. Those are not the cases that we see nearly as often, but those are the two exceptions right now. I would note that we are working on, we have seen some proposed legislation in Illinois to extend jurisdiction to 21 for everybody who may be SIJS eligible. That legislation, I think, is HB 4791, and it is pending in the Illinois legislature. Unclear what's happening with that right now, given the pandemic that's going on. So keep an eye out for that. But right now, the date that we're looking at is before the child turns 18.
Sorry, there was a question from Melissa clarifying that the state definition is 18 and over. Is that correct?
The state definition is 8. So when you are 18 in the state of Illinois, you're an adult, and then you're no longer subject to juvenile court jurisdiction. So you have to be under 18 in order to be subject to juvenile court jurisdiction, which means if you're over 18, you can no longer get a predicate order to make you eligible for SIJS right now, with those two exceptions that I explained. Does that answer your question? Okay. So there is a 3-step process to apply for SIJS. So the whole reason that we're here is that you can't just fill out an immigration petition for SIJS and have USCIS decide it. You first have to go into a state juvenile court and get this order with these special findings. So that's step 1. For those of you who are familiar with U visas, for example, I would compare it a little bit to that process, right? You can't just go ahead and fill out your application. First, you need someone else to give you some kind of certification. So the juvenile court predicate order is similar to that in that sense. The second step is the I-360, which is the petition that you're using to apply for SIJS. That can be approved, and then you would apply for adjustment of status, which is your I-485. Certain children may be able to do steps 2 and 3 at the same time. It's known as a one-stop in immigration lingo. Many of the children that we're currently seeing are from countries that are backlogged, and therefore they have to do steps 2 and 3 separately, and we'll talk about that a little bit more in the next section. So, and this is a little bit more about the immigration timeline, right? So you need to obtain that juvenile court predicate order, usually before the child turns 18. You would then file the SIJS petition using Form I-360. That can take some months to approve. You would then file your green card application. This currently says it may be a 3 to 5 year wait to even apply. Given the backlogs that we're seeing from certain countries, that's probably looking more like 8 to 10 years. So we'll get into that a little bit more, but it is a long road for kids from the countries that are backlogged. And then if the child is approved, they become a lawful permanent resident, which is on their path to citizenship. And that means that removal proceedings against them can be terminated. They can move forward with applying for citizenship once they're eligible.
And Hillary, just to clarify, you mentioned that the predicate order has to be entered before the child turns 18. Does the SIJS immigration application also need to be received before the child's 18th birthday, or postmarked, or what's the rule on that?
So we try really hard to make sure that those are received before the child turns 18. There has been some confusing language in USCIS guidance about this. Previously, there was language that said as long as the predicate order was still valid, they will accept it. And then there's some additional language that says unless the predicate order is no longer valid simply based on age. So there is some age out protection, but because USCIS, because they are reopening the regulations about this, we just take it as a best practice to try very hard to make sure USCIS receives the immigration petition, like even the day before the child's 18th birthday. We anticipate some real crackdowns when they when the new regulations are entered into force. And we just don't want to mess around with that. But you could make the argument, if you can't get it in before the child's 18th birthday, you can make that argument. The only reason that predicate order is no longer valid is because the child has aged out. And what that means, right, is that the child is placed under someone's custody by a court, right? But on the day that the child turns 18, they're an adult. So poof, they're no longer under anybody's custody because they're an adult. So you want to get it in before the child turns 18, so you can say that order is still in effect. Does that make sense?
Yeah, thank you.
Sorry, this is Jane again. So 2 questions from the audience. The first is, if a minor is seeking emancipation, how does that affect her ability to obtain SIJS status?
That is a really good question. If a minor is seeking emancipation, they would not be under somebody's custody, right?
Right. I don't actually know the answer, but I would assume that they would no longer be SIJ eligible, because exactly for the reason that Hillary mentions, because a minor who's emancipated is essentially declared to be an adult under state law before they become an adult legally. And they would no longer be under a guardianship or the legal custody of a parent. So you wouldn't have a predicate order that says that they're placed under someone's custody. So I don't think you could do that.
Right. So remember, there's 2 parts, right, to that. Well, there's 3 parts to the predicate order, but the 2 parts that would be significant there, right? Maybe the minor wants to be emancipated because there was abuse or abandonment or neglect. So you would be able to say, yeah, that minor now can't be reunified with her parents because of that abuse, abandonment, or neglect. But in that case, then you're missing the custody piece, which is kind of the first step in that juvenile court jurisdiction.
Thank you. And then the second one is, you talked about extended jurisdiction. You have a predicate order and child has not yet adjusted. Do the courts in Illinois grant extended jurisdiction?
Sorry, say that again.
Regarding extended jurisdiction, if you are a predicate order and the child has not yet adjusted, do the courts in Illinois grant extended jurisdiction?
I'm not sure I understand the question. Can you clarify? Yeah, let me see if it's in the chat.
Then we'll continue.
You already have a predicate order and the child is not adjusted. So if you have a predicate order already, you should just file your immigration petition, and then it doesn't matter if the child turns 18 while your immigration petition is on file.
Yeah, you don't really need the court to extend jurisdiction. You just need that predicate order in a timely manner before the kid's 18th birthday.
Yeah, because you don't need the juvenile court to keep jurisdiction over a child throughout this whole process. You just need the court to have jurisdiction to make the findings that it makes, and then you need to submit your immigration petition while that order is valid.
Right. But to answer the question, it would be no. Like a guardianship court or a domestic relations court would not extend jurisdiction beyond the minor's 18th birthday.
Yeah, right now the only courts that, as I understand it, that extend jurisdiction would be child abuse and neglect cases and some juvenile delinquency cases. The court can keep jurisdiction until 21. But a guardianship case, a custody case, none of those, the courts don't have the authority. I think with the exception of certain types of like child support cases can be extended past 18 if the child is still in high school. And I don't even know in that situation if the custody order itself is still valid or just that child support obligation is still there. But most
just the child support.
Yeah. Okay, I actually see another question. Is a minor for whom a final adoption order has been entered still eligible to file for SIJS? You want to take this one, Rebecca?
A minor for whom adoption has already been entered? I'm not sure I know the answer to that question. Maybe not because they have new legal parents, or?
I would argue that you should still be able to get those findings. So if you have a child who's been adopted,
to go back into the case and amend the order. Yeah, well, you can do that in guardianship, so that would make sense. But I don't, since the child would have totally new legal parents, I don't know.
So USCIS guidance on this, I believe, says, oh, the adoption order already has the magic language, then yes, you're good. Yeah. So I believe, I can't cite you directly where it is, but there is USCIS guidance that says, like, yeah, adoption is basically exactly that situation, right? Like the biological parents cannot be reunified with that child. The court has already decided that. So if the adoption court enters those findings, the child doesn't suddenly become ineligible because they're lucky enough to have new legal parents that are not abusive, abandoning, etc. So yes, if the order already has all the findings, great, you can go ahead and file it. If it doesn't, and you see a child who's under 18 who has had that final adoption order, you should be able to go back into adoption court and say, hey, we need these findings. They're as to the bio parents, not the new legal parents.
Mm-hmm. And that should be the same for other venues as well. Like for a guardianship order, you should be able to go back, even if the minor has turned 18, you should be able to go back and amend a final court order, to my knowledge.
If the child has already turned 18, though, so that would be like a nunc-pro-tunc order, right?
Right.
Nunc-pro-tunc meaning now for then. I think there's still an open question about whether USCIS will accept the nunc-pro-tunc findings.
Yeah.
Because the child's already 18. I'm trying to remember. I think I have one pending right now that I have my fingers crossed about, but it's not clear to me. I think there was language in the past sort of disapproving of nunc-pro-tunc orders, but
okay,
you could try.
Yeah, you can get the order. Whether it'll work or not is the other question.
Right.
Yeah.
Right.
Okay.
Okay, so a little history of SIJS in Illinois. So this, so SIJS was created back in 1990. It looked very different back then. It was very narrow and limited. It was for kids who were in long-term foster care and who were already had been through dependency proceedings, right? Child abuse or neglect proceedings. And the SIJS created in 1990 was limited to those kids. And based on that act, and I think there were a couple of subsequent revisions maybe in the late 90s, they didn't do a ton to make it the way that modern SIJS is today. But based on the old SIJS, Illinois actually passed a law in 2003 incorporating that into our Juvenile Court Act, which is the act that governs child abuse and neglect proceedings. So it says kids in DCFS care typically are eligible for SIJS. Here's how you get that language in an Illinois-based child abuse and neglect proceeding. And it included those requirements that a child be declared dependent on juvenile court and that a child be eligible for long-term foster care. So that was 2003. 5 years after that, in 2008, was when modern SIJS was created. And that really expanded jurisdiction to far more children than were initially included. It removed the long-term foster care requirement, and it allows children to petition for SIJS based on harm by only one parent. So it's not just kids who are stuck in the foster care system. It is children who have been abused or abandoned or neglected by only one parent. And it doesn't require a child abuse and neglect proceeding. It can be declared dependent on a juvenile court or placed under the custody of a state agency or an individual. So that really expanded who can be eligible, and that was in 2008. That was federal law. That was a Trafficking Victims Protection and Reauthorization Act. But the Illinois law still stayed the same way and still included those old requirements up until last year. So Illinois just never updated its law, and that resulted in a lot of confusion, I think, for state courts and state court judges who are being asked to enter these requirements under the new 2008 law and would look to Illinois law and say, well, this doesn't make any sense. It says here, I can't enter these. This is only for, courts subject to the Juvenile Court Act. So what this law that passed last year did is it updates the Illinois law to reflect what federal law is. It's just bringing us into alignment with what federal immigration law says and just making very clear that all of those courts that we named at the beginning do qualify as juvenile courts and do have the authority to enter these findings in a regular custody case. So the Illinois law is Public Act 101-121. It amends 6 different Illinois laws, all of which have the ability to enter custody orders. So that's the Juvenile Court Act, the Marriage and Dissolution of Marriage Act, the Illinois Domestic Violence Act, the Probate Act, the Parentage Act, and the Adoption Act. So all judges governed by those acts should now be able to look to their own Illinois state law and see that they do in fact have the authority to enter these findings that may seem weird and overly immigration-based.
Mm-hmm. And this has been crucial in probate court, for example, because the probate court was previously, before this law went into effect, refusing to enter these, because juvenile, the law says a juvenile court, but juvenile court is not a term that state courts throw around. Like the probate court and the domestic relations court don't consider themselves to be a juvenile court. They would never use those terms to describe themselves. And so when they saw that, it was easy for judges to say, well, that's not us, so we're not doing this. So that we've seen some great positive changes, and I'll talk about that a little bit later.
Yeah. So, can I get us back here? Can I? Maybe I cannot. There we go. All right. So, House and Senate champions of the new law are Representative Jennifer Gon-Gershowitz and Senator Christina Castro. They did an excellent job getting this passed. It was signed into law by Governor Pritzker last year, and it is in effect now. So if any of you have cases to bring before a state court that falls into one of those definitions of juvenile court, you are welcome to march into court and say, Judge, the law requires you to do this. We would do it a lot more tactfully than that, but that's essentially what we would be saying. They have to enter these orders. And we'll go over specifically what that law requires. So more specifically, brings Illinois law into line with federal law. So the big changes are not just updating the law to be aligned with federal law. Judges are now required to enter these findings if they're supported by the evidence. And the evidence can consist only of a declaration by the child. So the Illinois legislature here is really saying, we're taking this seriously. We want you to do it. This protection is not optional for children who prove that they're in need of protection. Judges don't get to just say, we don't want to do it. You have jurisdiction and you must enter the order unless you very specifically find that you don't believe that this is the situation here. Major changes also include clarifying the definitions that we would be using of the abuse, abandonment, or neglect by a parent that the child has suffered. Previously, there were sort of different definitions of abuse and abandonment and neglect scattered across different types of statutes in Illinois. There were some definitions used in child abuse and neglect proceedings. There's a definition in the Illinois Domestic Violence Act. There's a definition of abandonment in the UCCJEA, which is just kind of a jurisdictional act. So this law really specifies which definitions you should be using. And which definitions judges should be looking to, so that we're not just all sitting there saying, does this feel like an abandonment case? Do we think this is abuse or not? It's clear under the law. And more significantly, abandonment now includes where a parent has died. This is huge for our kids because we see kids who either may have been abused or neglected by a parent who then died, or just kids who their parent is deceased, one or both of their parents are deceased, and that's why they're in this vulnerable situation. So the law has been clarified to say that meets the Illinois definition of abandonment. Okay, so these are the specific definitions. You're welcome to use this as a reference and look them up. I would also suggest looking up the Public Act itself, and that will lead you to each definition. But there's basically the exact same language in each of the different acts governing child custody. Abuse refers back to the abuse definition in the Illinois Domestic Violence Act, which is pretty broad, but you're welcome to read that. Abandonment includes, so not just when a parent is deceased, but the failure of a parent to maintain a reasonable degree of interest, concern, or responsibility for the welfare of the child. And then neglect refers back to the definitions included in the Juvenile Court Act, which is in child abuse and neglect cases. And that is a very long section on various things that can constitute neglect. It also includes the failure to perform caretaking functions as outlined in the Marriage and Dissolution of Marriage Act. So that act that governs divorces and child custody also has a long list of functions that parents are expected to perform for their children. And so neglect then is defined as the failure of a parent to do those things. It looks like we have some questions.
We do. So could you repeat what evidence you need to show the judge to support the findings, the child's affidavit, and how detailed?
Sure. So we'll get into this more when we go into the process for seeking a state court order. The law says that the evidence may consist solely of an affidavit by the child. We don't actually usually submit an affidavit by the child. That's not typical in most of these cases, in most regular custody or guardianship cases. Usually the adult petitioner is the one providing the information. That can be tricky sometimes in the cases of our clients where it's possible that the adult petitioner may not have all of the information that the child has about the harm that they've suffered. And so in those situations, if the judge is asking for it, you may want to submit an affidavit or declaration by the child. But usually, honestly, in juvenile court cases, the judges don't want to see the kids there anyway. Court is not a place for kids. Custody battles are not a situation where kids should be in court except in certain circumstances. So if your judge does want to hear from a child, it will probably be under some specific parameters that may include submitting a written declaration. It may include having an older child come in and testify in court, but it may also, for younger kids, for example, just mean they appoint a guardian ad litem or a child representative to interview the child outside of court and then speak on the child's behalf in court. It may include a child being asked to come in and talk to the judge in chambers. There's a lot of protections that I think Rebecca can also speak to in more detail.
Yeah, I would say having the child come into court is more common in probate court than in domestic relations. So domestic relations, of course, the court that hears all divorce cases, all child support cases, custody cases. There are many judges. It's a huge division. It's very busy. And so they're dealing with all sorts of issues, not only, child custody orders. So it's pretty uncommon. It happens sometimes, but to see kids in domestic relations. However, in the guardianship court, it's not that unusual for a child to come in, especially for a child that's over the age of 14. So in guardianship proceedings, a child over the age of 14 has the ability to what they call nominate a guardian. It doesn't mean that they get to choose, but it does mean that their opinion is given more weight. And especially for children who are 14 and older, the judge may very well want to lay eyes on that minor and speak to that minor either in open court if the minor is comfortable. I've seen that happen, or in chambers if the minor feels more comfortable just speaking to the judge privately. But the judge may want to hear from a kid who can speak for herself or himself about their experiences or whether they are in fact living with this person, etc. So relatively common, I think, particularly in a case like this where it's likely to be uncontested. So Hillary mentions that usually we try to keep kids out of court, and that's very much true for our average guardianship case that might be a fight between family members. But these cases tend to be uncontested. And so I think the judge is more open to having the minor there because they're hopefully not going to be traumatized by people arguing in front of them. So just be prepared for that if you have a case that the judge may actually want the minor to come in a guardianship proceeding.
All right, so that takes us into the state court process. Did that answer the question actually about evidence? We can also talk more about it as the state court process goes on. Okay, thank you. Okay, so Rebecca, do you want to take it away for the state court process?
Sure. I don't appear to have control over the PowerPoint, so can someone kind of move slides when necessary? Oh, here, I just got it.
Do you have it? Okay, good.
I do, I think, yeah. How does it,
I was just using the arrow keys.
Oh, uh-oh. How do you get to the next slide?
Are the arrow keys working for you?
On my keyboard?
Yeah.
Oh, there you go. It was not, but now it is. Okay, thanks. Okay, steps for obtaining a predicate order. So Hillary mentioned that predicate order is the term that we use for the order that you need from a state court to initiate an SIJ petition with immigration. So your first steps, if you have an SIJ case, you're going to meet with your client. The client is going to be technically the person seeking guardianship or custody. So our client in an SIJ case is obviously the minor that we're trying to help obtain citizenship immigration relief. But in the guardianship or the custody case, like for me as a legal aid attorney, my client has to be the person seeking custody. So CVLS, for example, would represent the potential guardian or the mother or the father in a custody case. So we're going to meet with the client, gather background information, see what sort of evidence they might have or be able to produce, figure out who the relevant parties are and the details of what has happened. We're going to draft and file the petition. If this is a case being done through CVLS and or the NIJC, we provide a lot of hands-on supervision to make sure that both your state court documents and the relief that you're requesting in your petition are in compliance with the law and have all the right language to be able to make this case successful. You're going to need a draft petition. So in guardianship court for kids, there is a set order that the court uses for every guardianship case that a guardian would just fill out and file. That is not the petition that you're going to have to use in an SIJ case. You're going to actually have to draft your own petition with the specific SIJ language and requests. So don't use that form order that you can find on like Dorothy Brown's website, for example. Form petition, I mean. And then service. So this depends on your venue. So we're going to talk today about the two divisions of the Daly Center or state court where you can get this, one being domestic relations and one being guardianship or probate. And the service requirements are different. So I'm going to get into this later, but in probate, for example, you don't need personal service. You just need to send notice or you need to publish. Domestic relations has a higher bar for notice requirements. So that's part of the reason why we were so anxious for the guardianship court to start doing these, because they're easier to get there. The bar is lower in terms of actually finding someone and personally serving them. But you want to make sure that you've complied with any service or notice requirements, complete service of process if necessary, wait for a default date as necessary. So wait for the person to either consent or receive notice and not show up so that they can be defaulted. File and schedule a motion for final hearing. So this is in domestic relations. And probate, you don't have to schedule that up. But in domestic relations, it's kind of the lawyer's job to move the case along, right? So you're not just going to get assigned a final hearing, you've got to ask for it. So in a domestic relations case, you're going to file a motion for a final hearing. You're going to prepare your client for testimony and perhaps the minor in a guardianship case if the minor needs to go to court. And then in domestic relations, they call it a prove up. It's when the advocate is going to ask the client questions in open court, usually with a court reporter, to get those findings on the record. And I'll get into the nuanced differences between the two court cases, but there's no quote unquote prove up in guardianship court, but you would have like a final court hearing or a status date in both venues. Okay, what kind of case do I file? So I mentioned this part, an SIJS predicate order can be obtained as the result of a case in which a court places the child in the custody of a person or an agency. So again, that can be a state agency, or it can be a guardian, or it can be a parent through a custody order, and declares the child the dependent on the court. The most common types of cases are the two that I've been mentioning, custody or guardianship cases, but can also be included in an order of protection that has custody findings included in that order, an adoption, and juvenile dependency and delinquency cases like Hillary mentioned.
I would just point out here too that while it is technically possible to get these as part of an order of protection, what I'm hearing from advocates who are actually working in the domestic violence courthouse, a straight up order of protection is unlikely, like the judge is unlikely to make a final custody determination in those orders. So I've heard from people who have advocated to get them. I think it is technically possible, but usually if there's a custody issue as part of an order of protection, the order of protection will be entered And then the judge would say, you really actually just need to go file a custody case. Or, you know, we can enter temporary custody, but we're not going to enter a final custody finding as part of this order of protection.
Right. Right, because the typical order of protection is a 2-year order only. And so the judge may not feel that they can make a final custody order in that case. Your question? Is there?
The ID, oh yeah, so Ilda says the IDVA does allow for final parentage orders. Right, so under the IDVA, the Illinois Domestic Violence Act, which governs orders of protection, right, our position is they should be able to do it. The law allows them to do it. So if you are in that position and you want to be advocating to try to get a judge in domestic violence court to make those findings, I'm sorry, typo, does not.
Where is that?
So this is in, so Ilda's saying the IDVA does not allow for final parentage orders. Okay, so the IDVA does now contain language saying that they can make the SIJS findings. So yeah, this may be something that that's not possible in most cases. My understanding is if it is a 2-year order and you have a custody determination, for example, a situation in where that might work is if the child is about to age out, right? You could say that the custody order is final for purposes of USCIS, but yeah, I think that the position of the judges, and as Yilda is saying, there's no final parentage order, makes this a bigger challenge in that situation. If you have an OP as part of a broader parentage case, that might be the situation in which you would try to combine the findings to make an order sufficient for USCIS.
Mm-hmm.
Do you have any other comments about that, Yilda? I think you're more of an expert on this probably than those of us up here. Seeing none. We can move on.
Okay. So we mentioned that so we mentioned that your first step would be to meet the client. And again, your client is the petitioning parent or the guardian, at least for the state court part of it. So that kind of changes, right? And that's part of the reason that we have this partnership between CVLS and the NIJC, because that, you know, you're the lawyer filing the predicate order case, your client is the petitioning parent or the guardian, and in the SIJ case, NIJC's client or your client is the child. So if necessary, meet with the child separately to preserve trust and confidentiality. If you need any tips on meeting with children or interviewing children, CVLS has a number of resources that we can send to you or share with you about tactics for interviewing children. You can even do that at our offices if you'd like to. We have like a child interviewing space with games and toys, even if it's not a CVLS case. That's fine if that would be helpful to you. Review all information with the client before filing. Obviously, you want to make sure you have accurate information before you file. You want to work with an interpreter to ensure the client understands the contents of the petition and the process. So if you need assistance in finding an interpreter, Hillary and I do that sort of thing a lot. We can probably hook you up with someone. Particularly if it's a pro bono case through CVLS, even if we need to pay for an interpreter, we can probably arrange for that. And then discuss the risk with the family members before filing in state court, right? So anytime a family is going to appear in front of a government agency or in front of a judge and go through security and present their ID, and there's always some risk involved, right? We have not seen any issues with this. Hillary, correct me if I'm wrong, to my knowledge in Cook County. I've not seen anyone picked up at the Daly Center, through some sort of family law proceeding, to my knowledge.
There was, not at the Daly Center, there was last year, as recently as last year, someone picked up in Markham, I believe. I think there was a prior criminal history there. I'm not super familiar with the case, but that's one where we can't make promises to clients that ICE will not show up, but we can say it's not something we're seeing often.
And I can't speak to like the collar counties or other courthouses, but I know that at the Daly Center, we're not really seeing that. But yeah, you can't guarantee it. So there's always some risk involved, and you want to make sure that they understand that and that they're comfortable with that. Drafting the petition. Pleadings look like standard family court pleadings, but should allege facts sufficient to support parental abuse, abandonment, neglect, not in the child's best interest to return to home country. They should include a request for SIJ findings in the prayer for relief. We have, sample petitions that we can send to you, or if it's a case with us, we'll review all of that carefully before it gets filed, but you want to make sure that you have accurate language that meets immigration requirements. Avoid any mention of the parent or sponsor's involvement in a child's journey to the United States. Hillary, do you want to comment on this, since this is an immigration piece?
So as far as the parent sponsor's involvement in the child's journey to the United States, we're just trying to make sure that the parent or sponsor is protected against allegations of smuggling. It's not really relevant to a family court proceeding. It's not particularly any of their business, and it potentially could be prejudicial when we get to the immigration piece of it. So I would just keep that out. We do want sufficient facts for SIJS. But usually if that has to do specifically with abuse, abandonment, or neglect, it should not really necessarily mean the specifics about how the child got to the United States.
Okay. Okay, e-filing with a fee waiver. I don't want to get too much into the weeds about this. I don't know how many of you will be e-filing these cases or not, but these cases for low-income clients, if they qualify for legal aid through CVLS or some other organization, can be filed for free with a fee waiver. And the form that you need to file is called a CLSP. It's a civil legal services provider, if your organization is a civil legal services provider. So this can get kind of complicated. The e-filing system is not at all intuitive. It's not that hard to use once you figure it out, but figuring it out is very difficult because the prompts and the titles of things that you need to use don't make any sense in the system. So if you are going to be filing fee waiver cases, in any type of case, you have to create a new payment account and select waiver as your method of payment. It's a totally separate account for filing things that are going to be filed with a fee waiver. You're going to pick an account name of your choice, follow the steps for e-filing a document. You're going to upload a primary document as your lead document, and then you need a completed CLSP as an attachment. And if you don't do that, your filing could be rejected. So this CLSP form is a form that civil legal services fill out to say, like, we are attesting that this client is low income and that we're a civil legal services provider and that we represent this person. It's a pretty basic form, but it has to be filed with each separate document, or else you could be rejected. And the e-filing system isn't that great because, like, you can file something and you can be like, hey, I think I did this right, this got filed, and then like a day or two later you might get notice that it was rejected, and that can be especially important if time is an issue. So you want to make sure that you've done everything correctly so that it gets accepted the first time around. If you need any help with this, you can contact CVLS. We have, like, it was hard for me to upload into a PowerPoint, but we have manuals and screenshots and things that we can send you with a more detailed step-by-step instructions for this. Okay, and then your predicate order in your petition should mirror the necessary findings that you're going to need to have in that predicate order that you're going to submit to immigration. So this is sort of Hillary's territory, but you're going to want to make sure that the petition and the order reflect each other, so that you're asking for the specific language that you need in that predicate order. So number one, that the child's reunification with one or both parents is not viable due to the factors that you've outlined, abuse, neglect, abandonment, or a similar basis under state law, which now Hillary mentioned includes the death of a parent or both parents. And three, that it would not be in the child's best interest to return to her home country. So for those of you who do immigration cases or are familiar with them, often you have to include lots of information about home country, right? So submitting State Department documents and reports on what's going on in Central America, things like that. I don't know about domestic relations, but at least in guardianship cases, that is absolutely not necessary. So the judge will be, at least for guardianship, very willing to enter number 3. Not a lot of concerns there, from my opinion. You don't need to attach 10 exhibits as to why their home country is dangerous, or information about, gang activity or anything like that. So it's mostly more important to focus on number 1 and number 2, and the judges will want some specific information about why the court should enter these findings. Why can the child not be reunified with their parents? Have they been abused, neglected, abandoned? Are the parents deceased? And any documentation that you can provide on that is helpful. So Hillary and I had a case recently where one of the parents was deceased, and the judge really wanted to see some kind of proof of that, even if it was just a photo of the gravesite from a cell phone. Ideally, a death certificate, things like that are obviously better, but any information that you can obtain to support your petition, including affidavits from multiple people, are helpful. Hillary, I don't know if you have anything to add on that.
Yeah, I would just say about number 3, I think this one can really trip up both, advocates and judges. I've definitely heard judges say, are you asking me to grant asylum? Like, this is not an asylum case. Why would I say this child can't go back to her home country? Because it sounds sort of like the judge is making an immigration determination, right? If the judge is saying it's not in the child's best interest to return to their home country. So this is where, if you're before a judge who's unfamiliar with SIJS, number 1, you get to point to the new Illinois law that says, yes, you have jurisdiction to do this, and yes, it includes this language. But number 2, it's really important to explain here, this finding number 3 is not an asylum finding, doesn't have anything to do with this child's, does not mean there's any final determination about this child's immigration status. The juvenile court judge does not control whether this kid ultimately gets deported or not. That is still up to the immigration authorities. This judge is just making a best interest determination. So I think you could compare it to you judge would get to determine if it's in the child's best interest to live with mom or dad, or if it's in the child's best interest to live with ex-guardian or to return to their previous living situation. So it's more comparable to that. Is it in the best interest of the child to stay here in Chicago with ex-guardian, who is your petitioner, based on, that person and the child's testimony, or is it in the child's best interest to go back to Honduras, for example? So you wouldn't be providing extensive documentation like you would for an asylum case. This would still just be based on everybody's credible testimony. Maybe you explain, for example, if, let's say, mom is still living in Honduras and child is here with a guardian, you might want to do a brief explanation of, well, child can't live with mom in Honduras because of XYZ, right? They may have received threats from gangs, or mom may have been the one doing the abandoning. So explaining why there's not an adequate caretaker in home country might be important, but it is not the same level as that explanation in an immigration case like asylum.
I think there was a question. I'm having some trouble navigating this chat function. Can anyone see the question?
Yeah, sorry, I can bring that up. It looks like it was from Hilda, sharing, for the most part, you're able to tie number 3 to the best interest of the child. So I don't see a question.
Oh, okay.
Yeah.
All right. Oh no. Sorry. Okay. Okay, Hillary, do you want to do this one?
Sure. So you want to make sure that your petition, and particularly your final order, are citing to the appropriate definitions of abuse, abandonment, or neglect, and then providing supporting facts. So previously we cited to a variety of different types of definitions. Now the definition you use should be in the act that governs the type of case you have, right? So that may be the Probate Act if it's a guardianship. It may be the Parentage Act or the IMDMA if it is a custody case. But you do want to look at, oops, we went backwards. Make it go back, Rebecca.
I don't have control over this
Oh my goodness.
right now.
Let me see if I can do it. Oh, it's amazing. Zoom is my favorite. Okay. So you do want to cite to the appropriate definition, and then you want to provide maybe 1 or 2 sentences of facts supporting why the actions in this case meet that definition, right? So the respondent parent neglected the minor children pursuant to this particular definition in that she or he failed to provide food, shelter, and economic support, had substantially no relationship with the minor child, right? Or if it's an abuse case, you provide 1 or 2 sentences about the abuse. It doesn't need to be a full affidavit. The judge may have more questions for you at the time of the final hearing, but you want to make sure that there's sufficient information to show that the facts in your case meet the legal definitions that you're going for.
Okay. And your next step is going to be service on the respondents or respondent, depending on who your parties are. So this may be the other parent, or it may be both parents if you have a guardianship case. And again, these requirements are different for a guardianship case than in a domestic relations case. In an ideal world, you will get a consent form from any living parents that you can find. I realize that that's not always possible depending on where they are and if they're cooperative. It can also be tricky because the petition is saying that these parents have abused, abandoned, or neglected their children, right? So they may not be comfortable signing something that says that they have abandoned their kids, and that's understandable. So this really varies a lot by case and by family. I have in the relatively limited number of cases that I've done directly or spoken to the families directly, the parents have been happy that their child is getting a path to citizenship in the United States and have been willing to sign, but I could understand why in other cases they might not be. So that's something to discuss. If you can get a signed consent, that is far and above the best path through it, because they are submitting themselves to the jurisdiction of the court, and that's all that you need. Then you don't need publication, and then you don't need all these other things. So your cases get a lot easier if you can get that, but obviously that's not possible. So you may have to publish, or you may have to obtain personal service. So that's why the second part says, otherwise determine how service will be made. And there's a note at the bottom, only notice, not service of process required in guardianship cases. So guardianship is an easier way through this, but of course guardianship is, and I'll get into this in a minute, only for when kids are living with a non-parent. If a child is living with a parent, you've got to go through domestic relations. Okay, so the different service requirements are going to depend on where the person is, what the circumstances are, and to some extent the judge, from what we've seen, right, Hillary? That some judges will be more stringent about what type of service you're going to need. So, Hillary, do you want me to go through all these different things, or is this like too detailed for the audience, or is this helpful?
Yeah, can you all let us know if this makes sense and if we need to get into the weeds on service? Any chat?
Okay, more details are better. Okay, I am not an expert in this because I practice only in guardianship court, but I will do my best. So if you are serving someone in Illinois, so let's say one or both of the parents live in the state of Illinois, you're going to need to get personal service on those individuals or obtain that consent and waiver that I mentioned. So again, written notarized consent, always the best path through this if you can get it. Or you can serve them by publication. So if you don't know where they are and you can attest that you've done your due diligence to try to find them and still don't know where they are, you can do service by publication. So for anybody who doesn't know what publication is, it's you run this announcement in a specified newspaper that nobody reads for a specified period of time, and then the court is like, okay, they've been served by publication, that's good enough, and we can default them in this case. or by special order of court. I'm not totally sure what that means.
So I would just give the caveat that like service sounds very scary and there's a lot of other statutes that deal with it. This was something that took me a long time to figure out when I was starting to do these cases, because we were like trying to serve people and mostly they're in a foreign country, and are these like things where the governments have to talk to each other, or like special conferences between the judges? Honestly, usually what we're doing is consent and waiver, publication, or sometimes personal service by somebody who is just not a party to the case. So I put in the special order of court just as a way to have a citation for the court's authority to appoint somebody else to do personal service. So for those of you who've done family law before, who've done domestic relations cases, usually this is straightforward because the respondent lives in Illinois, you file the petition, and then you hand the summons to the sheriff, and the sheriff finds the person and serves them, and then it's done, right? Where somebody is living outside of Illinois, that gets a little bit trickier because the Cook County Sheriff is not going to serve somebody in Guatemala, right? Or even in Indiana, you have to like consult with the other state or country that you are working with. What we have had success doing in multiple cases is having the court say, okay, I'm authorizing this person in Guatemala, whose name and address I have, to be the special process server in this case, to sign an affidavit saying, yes, I handed a copy of this petition to the respondent on this date, and they sign that affidavit, and then we return that, we file with the court, and we say, okay, personal service has been completed. And the additional statutes here really are, and I think Rebecca pointed out, this is really about the judge. The reason for service of process and for notice is just to protect the due process rights of the other person. And so anything that we're going to do is going to be to try to show that the other person has had a reasonable opportunity to respond to this case filed against them. So in many cases, it's been sufficient to say, okay, this person says they handed a copy to dad in home country, dad has been notified, dad is not here, we're going to go forward. I think same thing with publication. So publication is if you cannot find the person or if the person is evading service. Illinois' publication statute also says if the person resides outside of or has gone outside of the state of Illinois, many judges will want a little more effort than that. They won't just want to go forward on publication if you say, well, the person doesn't live here, because if you know that person's address and can make an attempt to find them, they really want you to see that. So service sounds trickier than it is usually, is what I would say.
Yeah, I agree. So Hillary has already covered the information in some of these slides, but so personal service, like she mentioned, can be by a sheriff in Illinois. Again, only for domestic relations, this does not happen in guardianship, or by an individual by the court if outside Illinois, like what they call a special process server, or somebody who has been authorized to serve by personal service. Publication, if the whereabouts are unknown. Again, Hillary mentioned apply to somebody inside the state of Illinois and sometimes even to somebody outside the state, depending on your case. And then consent and waiver. This is a piece of paper that the other parent or both parents might sign, ideally notarized, making service unnecessary. So I already mentioned this note at the bottom, but even an abusive or neglectful parent might be willing to sign a consent and waiver of service. Discuss this possibility with your client first. So we do see this happen. That parents, they know that they haven't seen their kid in a long time, that they haven't provided support to their child. And, if they hear that the child is going to be able to stay in the United States legally as a result of this case, some parents are willing to sign, even if the petition contains negative information about them.
I just want to point out, we got a really good question that says, for those of us who are practices limited to immigration law, the best thing to do is get a family law practitioner to do this for us. This is an excellent question. Yes, if you do not have competence in an area of law, the best thing to do is to find someone who has that competence, either to do it for you or to help you attain that level of competence to kind of mentor you through it and do it yourself. So yes, at NIJC, I do technical support to folks doing these, but I don't usually appear in family court. I partner with CVLS, who has the expertise in family law, or with the pro bono attorneys who are doing the family law piece of it. So yes, refer to a family law attorney if that is what you are comfortable with. If you're comfortable trying to jump in, just make sure you have somebody to mentor you through the process so that you are doing it appropriately.
Yeah, and I agree. And that's why we have this partnership, because the NIJC has the immigration expertise, and a lot of you do as well. And CVLS does not. Like, we are not immigration attorneys, but we are state court attorneys. So we are in guardianship courtrooms and doing guardianships and divorces and custody cases every day. So while I am not the director of our domestic relations program, we have a huge domestic relations program at CVLS. We do tons of divorces and custody cases. So we are able to do these predicate order cases for the NIJC and for any of you. So if you have a case that you would like to do, but you are not quite sure how to do the state court aspect of things, you can let us know, or you can even do it if you want to with our supervision, with our materials. And ILDA and some other agencies also have that state court expertise to be able to do these predicate orders.
Another really good follow-up question. Is there an equivalent to an accredited representative, i.e. a non-lawyer for family law?
There is not. The only thing that I could think of that might be similar would be like a student who has a 7-Eleven license. You know, they're not a licensed attorney, but with a 7-Eleven license, they can go to state court with the supervision of a legal aid organization. But there's not an equivalent of a non-lawyer who has like a license to practice in family court.
So to avoid unauthorized practice of law, you really need to partner with someone who is a lawyer and licensed to do this work.
Yeah. Okay, so we've been through some of this already. Service versus jurisdiction, these are two different things. So service is like notification, right? So this ensures that you've properly notified the opposing party about the case. So those are going to be the parents, one or both parents in an SIJS case. And in a guardianship case, adult siblings are also entitled to notice. So like if you have an aunt who's trying to get guardianship of a minor and the minor has adult siblings, those people are also entitled to notice under the statute. But again, not service, just notice. So if that person has never been to Illinois, the court may not have personal jurisdiction over that person, even if they were properly served. But the court does have subject matter jurisdiction over the custody of a child who resides in Illinois. So the UCCJEA is the law that governs whether or not a court has jurisdiction over a child. But a rule of thumb, kind of a quick and dirty way to think about it, is that if the kid lives in Illinois and has been living here for some time, especially if it's been more than 6 months, the court probably has subject matter jurisdiction over the child and over a custody proceeding. You may not need the court to take personal jurisdiction over the respondent, depending on your case. And there are a number of bases in which the court may assert personal jurisdiction. Again, Hillary and I are not seeing like, I don't want to speak for you, Hillary, because you see more cases than I do, but not seeing a ton of issues with this, right? Like we're mostly dealing with cases where we have a consent from the parents, or the court is accepting compensation, or the court is accepting some sort of more informal service. I had a case in Guardianship where we sent the parties the documents by WhatsApp, and we had like a chat with them, and I was able to take screenshots, and the judge could see that we had sent them the documents via WhatsApp, and I had explained to them, you know, what this means, and she accepted that as sufficient, and they signed something, and they took a photo of it with their cell phone and sent it to us. So at least in probate, we are seeing a fair amount of flexibility on this. Hillary, I don't know if you want.
Yeah, I think different judges will just have different requirements. It really depends on kind of what your judge is interested in. I think once you are able to explain what you are doing and that you have the legal basis to do it, that is hopefully enough to get a judge on board. However, there are some judges who are pretty concerned about their jurisdiction to enter certain types of orders, and who are very concerned about, in general, who are just more sticklers about things like service to make sure the other party's rights are protected. As far as the service versus jurisdiction distinction, we may get into this a little bit later, but this usually just comes up if you need to establish paternity. So we'll talk about it a little bit more, but if the child's father's name is not on the birth certificate, and we are saying that it is the father who has done the abusing or abandoning, USCIS requires us to have the juvenile court establish paternity. And that can get tricky if the father has never been to the state of Illinois and the judge in Illinois may not have personal jurisdiction over the father. If you have a situation like this, feel free to reach out to me. There are some bases upon which a court can take personal jurisdiction over someone who hasn't been to the state of Illinois. It would involve some just some significant legal arguments, right? So we can talk about that on a case-by-case basis. In general, it should be clear that the court has jurisdiction over the child, over the custody of the child, and the child's best interest, and in most cases that is enough.
Thanks, Hillary. I see some questions online, so I'm going to read these from Melissa. And as an immigration practitioner, can I get a copy of the judgment order? How is the procedure in place to obtain a copy of the court record, including the predicate order? So for domestic relations cases and for guardianship, I'll get into this in a minute, but guardianship and probate are the same thing. Those are all public record. So if you're asking for an order that's already been entered and you want to get a copy of it, you can obtain that easily from the Daily Center. Anyone can go there and pull any file. Guardianship is going to be in 1202, for example, to the clerk's office, pull the file, make a copy of the order, or if your organization has access to the online system where you can pull orders from domestic relations, you can just pull it up. So they are not sealed, it is not private, and anybody can get a copy of that. And then the other question,
that you'd be looking for the name of the petitioner or respondent, right? So you'd be looking up parents' names, not child's names.
So the good point. So in a domestic relations case, you're going to be looking for the parents because the domestic relations case is mom versus dad and is going to be labeled as such. And then in a probate case, you're going to be looking for the child's name. So a probate case is estate of Jane Doe, the minor's name. And then, and if you have any help with that, if you need any help with that, feel free to contact CVLS. We're over there pulling files all the time, and we could probably even pull it for you. So if you want to just send me an email saying, hey, I'm looking for the order from whatever case, we can get that for you. And then there's one that says that a prior DePaul SIJS training, the family lawyer mentioned that the guardianship judge in Chicago was particularly difficult to work with in these cases. That was me. Is the new judge any better? The answer is yes. So positive developments all around with the changes in the law and also a new judge in the guardianship courtroom. I'm going to get into this in more detail in a few slides when I talk about guardianship. But yes, we have a new judge as of a few months ago, and she is so a number of things that I mentioned last time that were difficulties. She is now granting guardianship to undocumented petitioners. So this is relevant probably to all of you for just regular guardianship cases, not just SIJS cases. If you have people in your community who need to get guardianship of a minor and those adults are undocumented, last time I spoke with all of you, I mentioned that the judge was not doing those. The law does not require citizenship or lawful permanent residence to get guardianship of the child, but the judge was interpreting it to mean that, and that has changed. So now if you are undocumented and you need to get guardianship of a kid who's living with you, you can do that in Cook County. Likewise, the judge is also entering these SIJ findings now, both because I think she would have done it anyway once she had been educated on the issue, and also because of this new law that is now in effect. So we no longer have that issue, and guardianship cases can and should be brought in probate as the easier of these two venues.
So there's one more question that is a good one. We'll do a quick review. So when would you get a predicate order in a domestic relations court? So can you give an example? So this is all about who the child lives with. So you're looking at the child and their eligibility. Who do they currently live with? Do they live with a parent or a non-parent? If they live with a parent, then that parent needs to file the case, meaning it may be a custody or a parentage or a divorce case. If they live with a non-parent, then that would be a guardianship. It's basically, do you have any other exceptions to that? I think it's essentially that simple.
No, but it is confusing because before this positive change in probate court, technically non-parents could and were, could go and were going to domestic relations to get what we call a third-party custody order. So long story short, custody, domestic relations is for parents, guardianship is for non-parents. So like Hillary said, where you file depends on who the kid is living with, but it's muddied because a non-parent can actually go into domestic relations and get a third-party custody case. So instead of getting I'm an aunt of a kid. Instead of getting guardianship, I could file in domestic relations and get custody of a child. But it's a higher bar, it's a higher standard, the requirements are more stringent. And so if the child is living with a non-parent, those cases really should be brought in probate because that's where they belong and because it's easier for us to get what we need for an SIJ case. We were making an end run around the probate court because the judge was not entering these, but now she is. So I hope that makes sense. Okay. Do I have the slides? Oh. Jurisdiction. Do we need to go?
I think we can go ahead and skip through jurisdiction. If folks have specific questions in a case where they think jurisdiction is an issue, you can feel free to reach out unless we see something more significant. So this is what I was talking about as far as personal jurisdiction over a non-resident of Illinois. For the most part, you should not need to worry about this because you don't need personal jurisdiction over a respondent to make findings as to the best interest of a child.
Okay, skip this one too?
I would go ahead and skip that one.
And this one? No.
So yeah, this is just the UCCJEA. So this says that where a child has lived in a state for at least 6 months, oops, having audio problems. Can you hear me? I don't think I'm muted. Yeah, okay. UCCJEA governs what courts have jurisdiction over child custody, as I think Rebecca already mentioned. So if a child has lived here for at least 6 months, with a parent or a person acting as a parent, that's the child's home state. That means that a juvenile court here has jurisdiction to hear that child's case. Even if a child has been living here for less time than that, the court may still exercise jurisdiction over that child's custody. Kind of depends on your judge what they would want to do in order to exercise that jurisdiction. In many situations, because these are default cases and nobody's contesting jurisdiction, it's a non-issue. If the judge has questions, I think, you know, you could say the fact that the child is here, there's no other court that currently has jurisdiction over this child or that could take jurisdiction over this child means that, you know, we need this court to take jurisdiction.
Right, and I agree with Hillary. That's what I see also in state court, that the UCCJEA is somewhat meant to deal with disputes. So like if two courts were entering competing orders of custody over a child, or if a court in Indiana entered some sort of custody or guardianship order over a child in the past few months, that could be an issue. But as Hillary mentions, if no other court has exercised jurisdiction over this kid, and the kid has lived in the state of Illinois for less than 6 months, you might still be fine. I don't see a lot of this unless, like I said, there are other court orders from another state. So if a kid, you know, just got here recently from Las Vegas and the court in Las Vegas has entered some sort of like domestic relations order or guardianship, that's an issue. And the judge might reach out to that court to see what the situation is, or the judge might say, we don't have jurisdiction over this kid. But for the most part, in the absence of other court orders, if the kid has been living here for a little while and it seems likely that the kid is going to stay here, I find that at least the guardianship court is willing to enter orders in less time than that. Okay. A motion for default. So again, this is in domestic relations. So in domestic relations, like I mentioned when we first started, you as the advocate or the attorney is responsible for moving your case along. You have to take steps to say like, okay, we're moving on to the next phase of this case. I'd like to file a motion for our proof update or for the next stage. You have to affirmatively file stuff to get it moving. So you're going to file a motion for default to be scheduled 30 days after personal service or publication. So like if the mother is your client and you're serving the father, for example, you're going to file to default that person. So that person has received proper notice. You can show proof of that either by personal service or that you published and you allowed the specified amount of time to pass. And now you're going to move to default them. So you're asking the court to enter an order saying this person got notice and hasn't shown up, so we're going to proceed without them. That's what defaulting someone means. And then a final hearing can be requested immediately if you're proceeding by consent or if the respondent is deceased and you have proof of that. Okay, so a lot of what we just talked about, personal service and the motion for default applies again to domestic relations where the child is living with a mother or a father. I'm now going to talk more specifically about guardianship cases in probate. These are cases where the child is living with a non-parent. So an SIJ case where the kid is living with an aunt or sometimes an older sibling. Those are cases that can and should be filed in the probate division, and those are guardianship cases. So I'm going to do a quick overview of what guardianship is, in case some of you are not familiar with guardianship or haven't dealt with this in the past. Guardianship gives the daily decision-making authority over a child to someone who is a non-parent. So it allows a non-parent to step into the shoes of a parent to make day-to-day decisions for a child, such as where the child lives, where the kid goes to school, choosing a doctor, normal day-to-day decisions that normally a parent makes. However, guardianship is distinguished from other types of custody and adoption and juvenile court cases. Parental rights under a guardianship are not terminated. So this is not an adoption, and this is not a juvenile court case where the court is going to be deciding that parental rights should be terminated. Mom and dad remain the mother and the father of the child. Even if a probate guardianship is in place, they still have rights. They have the right to visitation, and they have a right to petition the court to discharge or to terminate the guardianship at any time. So it mentions here, parents can petition to discharge at any time. So guardianship was meant to be a temporary construct, and parents have a right, as long as the minor remains under guardianship and remains under the age of 18, to come before the court and say, hey, I want to terminate this guardianship. I want my kid back. And again, a lot of semantics here, but guardianship is for non-parents and custody is for parents. So they essentially mean the same thing, right? Like the day-to-day decision-making power over a child, but guardianship is only for non-parents. So a mother or a father would never have guardianship over their own children. You would only ever have guardianship over a child that is not yours. A mom or a dad has custody of their own kid. In Cook County, guardianship cases are heard in probate court. So the probate division of the Daly Center deals with decedents' estates, so dead people and what they've left behind to their heirs and whatnot. Guardianships of disabled adults, also something that CVLS does a lot of. So if you have people in your community who are taking care of an adult over the age of 18 who cannot make their own decisions, so somebody who has dementia or somebody who's severely disabled, they need to get guardianship over that adult. That is also in the probate division. And if you have questions about those types of cases, you can contact us.
I would jump in real quick about that and say, if you have an 18 to 21-year-old who is the subject of a disabled adult guardianship, as much as it seems like you should be able to get SIJS findings in that situation, you cannot, because it is not a juvenile court at that point. It's a court with jurisdiction over an adult with disabilities. So important distinction. We're still, under current law in Illinois, looking at under 18-year-olds in minor guardianships, not adult with disabilities guardianships.
Mm-hmm. Thanks, Hillary. So in Cook County, believe it or not, guardianship cases are now all heard in only one courtroom in front of one judge. We used to be able to have guardianship cases heard in other places, but that is no longer the case. Everything has been consolidated to one very busy, very hectic courtroom, and that is room 1806 of the Daly Center, and the judge is the Honorable Judge Stephanie Miller. So this is she's not super new anymore, but she is, for our purposes, the new judge, and she, by all accounts, in my opinion, is excellent. She has a lot of experience as a litigator and experience working in the juvenile court. So she's very well aware of all of these issues that we have discussed, jurisdiction, child welfare, custody, and super knowledgeable about how the juvenile court works. and has proven herself to be very open to being educated about these cases, and is now aware that this new law is in effect and has been entering them without much issue. So we are very happy with the situation in probate and hope that she stays there for a while. I think we might have a question. Is there a good list of screening questions to use with potential clients to assess eligibility for predicate orders? Hillary?
I have a form that I use. I'm happy to disseminate that.
Okay, thank you. And how do Illinois courts treat Carta de Poder or foreign guardianships? That's a good question. I mean, in some cases, you might be able to just simply request an entry of a foreign decree. So if you have an actual like custody order from a court in another country, you may be able to file what's called a petition to enter a foreign decree. So this is another court outside of Illinois, outside the United States, that has already dealt with this exact issue with these exact parties and entered a custody finding. You may be able to just simply enter that in the state of Illinois. If you're talking about a Carta de Poder, like something that was signed by a parent saying like, I'm giving custody of my kid to so-and-so, and they signed it with a notario, that's something that you can use to, and Hillary, maybe, I mean, Ilda, maybe you want to comment on this too, but I would just bring that as like, provide that as proof of your guardianship case, or well, I don't know about domestic relations, but in a guardianship case, that was something that ideally you would want to get translated and show to the court in support of your case. Ilda, I don't know if you want to comment on this. I think you may see more of this than I do. Yes, no. Okay.
I would point out that Ilda attaches it as an exhibit.
Yeah.
I would point out, if you do have a court-ordered custody or guardianship from another country, as opposed to just a Carta Poder, it is somewhat of a complicating factor, right? Because as Rebecca mentioned, it would be kind of a separate petition. You wouldn't begin a custody case in the same way. You would be doing a petition to register that judgment. And then usually you'd have to also do a petition to modify it, because it's very unlikely that the foreign country court would have entered the exact language that you need for SIJS.
Right.
And so you would still probably need to get a hearing before a judge here in Illinois, who would then make those very specific findings.
Yeah, that's what I would recommend as well. Even though technically, you know, it's still the, you know, roughly the same, or like you're still asking for the same thing that the foreign court has already entered. Like Hillary says, you need all this other stuff. And so in my opinion, it's better to just file a new case and attach that as like evidence or proof to support your case, or an exhibit. Yeah. That's what we do.
I call that advanced family law, and I would probably refer that to CVLS or Catholic Charities, because it's a little more complicated.
And we have people who can do translations. There's another comment here. I usually argue Carta de Poder is useless under civil law. Tutela or tuition.
Yeah, a tutela is more likely to be a court-ordered situation, in my understanding, as opposed to just a Carta Poder. So that's one where you would want to really look at whether this came from a court in a foreign country, and then you would be looking at probably filing a petition to register and modify that.
Mm-hmm. Okay. So moving on to some basics about guardianship. I'm going to go over this quickly because I think I covered this last time, and I may be talking to exactly the same group as before, but just to review who can be a guardian. So again, all this is state law, but in the state of Illinois, the statute requires the person to be at least 18 years old. Every time I give a community presentation on this issue, somebody asks me, can I appoint my adult son or daughter as the guardian of my younger children? And the answer is yes, if they are at least 18 years old. It's important to think about whether an 18 or 19-year-old has the ability and the maturity and the resources to be able to take care of young children. But yes, technically anybody over the age of 18 can be a legal guardian, 18 or older. They need to be a resident of the United States. So I wanted to go over this again because this is the thing that has changed. So the Probate Act requires that a legal guardian of a child or of a disabled adult be a resident of the United States with a lowercase r, just like it's written here. And this means, in my opinion, in the opinion of most judges, that they simply need to live in the United States. It does not speak to their immigration status. So this is what the judges who did not want to do these were hanging their hats on. They were saying, look, you know, the statute requires them to be a resident, and you know, somebody who is undocumented is not a resident. They're not a permanent LPR, they're not a citizen. So, but this has changed, and the courts, I have seen judges ask this question of petitioners under oath, and they'll say, are you a resident of the United States? And the person who might be undocumented will hesitate. And some of the judges will say, do you live in the United States? So we're seeing, with a few exceptions, some relative consensus among the judges that this does not require lawful immigration status. The presiding judge of probate has also changed. So we have more favorable circumstances all around from the top down. The person has to be of sound mind, so they have to be sane and not adjudicated a disabled person by the court. So this doesn't mean like, are they receiving Social Security disability? This means, has a court of law determined that that the petitioner is a disabled person in need of a guardian themselves? So they need to be somebody who can make day-to-day decisions for themselves and for a child. The person should not be convicted of a felony. This is not an absolute bar. So the statute says that someone with a felony conviction can still be appointed as the guardian of a minor, but the court is going to determine this on a case-by-case basis. So they're going to need to decide, you know, have a hearing, consider all the evidence and testimony, and decide that even though this person has a felony, they can still, it's still in the best interest of the child that the person be appointed. So this is kind of a common sense analysis. There's no bright line rule, but basically if your potential petitioner has a felony conviction, it should be something hopefully old, and hopefully something that does not deal with the welfare of a child, you know, like mail fraud or something, you know, or something that happened a long time ago and doesn't involve children. If they do have a felony involving harm or threat to a child, especially a felony sexual offense, that is an absolute bar for obvious reasons to obtaining guardianship of a minor. Okay, predicate orders in probate. So we've gone through this a couple of times already, but this is again appropriate when a child is living with a non-parent. So an aunt, an uncle, a family friend, all of those people can be guardians in probate court. No blood relation is required, and there's not really like a hierarchy. So it's not like people who are related by blood get first dibs on guardianship. Anybody can be the guardian of a child if they meet the requirements. And again, these are heard in Cook County and at the Daly Center, 1806, in front of Judge Stephanie Miller. I just went through all of this, but the probate court is now granting guardianship to undocumented petitioners. So even for just straight up guardianships that don't involve SIJS, so if a kid is a US citizen and is living with a non-parent, you can now bring those in probate court. And we are seeing those being entered without issue. And now the court is also entering SIJ findings. So some logistical and practical notes about probate court. We've been through service requirements, so you don't need personal service in a guardianship case, which makes it significantly easier. You need notice only. So that means that you need to send notice to the person by certified mail if you know where they live, or you need to publish. And again, consent is always best. So if you can get that notarized consent form, that is always ideal, but things are a little smoother in probate court with regard to sending notice or publication. And then that you need to send notice to parents and to adult siblings of the minor. I mentioned that already. So other details about 1806, there is no court reporter. So this is different from domestic relations. In domestic relations, you will have a court reporter for nearly every court appearance that's recording everything that's being said. That can be, you know, a good thing or a bad thing, depending on, you know, what you want or what you are looking for, what's being said. It can sometimes be to your advantage or to your disadvantage. But if you need a record of what is being said, particularly like if the minor is coming to court and is going to testify, or for some reason, or you think you might need to appeal. So if you are, anticipate things going poorly, like in another jurisdiction or another county, you could see whether they have court reporters there, and if they don't, you might need to bring one, even if you have to pay for it, so that you have a written record, so that you can appeal the case if you think you might need to. We don't see a lot of that in 1806, but sometimes we do, but it's not provided by the court. Interpreters are, though, so if you have family members and petitioners who don't speak English, the court will provide an interpreter, but they can take a while to show up. So make sure when you get there and you check in that you let them know that you need the court certified interpreter, so that they can make sure that they call the interpreter if they haven't already. And you can kind of have to sit around for a while because the interpreters are stretched pretty thin at the Daly Center. So just make a note of that. And so I have on here CVLS's relationship with the court. So because we do so many guardianship cases in Cook County, we have a very close relationship with Judge Miller, and she knows us very well. She is accustomed to working with CVLS cases every single day in her courtroom. So I have that on here because we have, to mention what I've mentioned already, that we have volunteers who are willing to do these predicate order cases. If you don't feel comfortable with the state aspect of these cases, we can place them with volunteers who are working under CVLS's umbrella. But also because if you bring a case and for some reason things don't go well, you hit some unanticipated bumps in the road, or the court is questioning something about your case, you can, and this is in domestic relations too, you could ask that a pro bono GAL or a child rep be appointed. So my real job is not this. I am a GAL or a guardian ad litem for children. So that means that in guardianship cases, CVLS gets appointed as the representative of the child. So a guardian ad litem is somebody appointed to represent the best interests of a child. So that's what we do. And that's my day job, is to serve as a child advocate and to represent kids in guardianship cases. And so, and we do that also in child rep. So we are doing 200 to 300 of these cases a year in both venues. So my colleagues at CVLS also represent kids in custody and divorce and parentage cases. So in either venue, if you are running into issues, particularly in domestic relations where we have lots of judges and things may be a little bit more unpredictable in terms of service and what the judge might require and the judge's familiarity with SIJ, you can ask, I mean, they may say no, but you can ask the court, like, hey, would it, could we possibly appoint a GAL or a child rep to represent the best interest of the child in this case? And most likely that case will come to CVLS and we will be appointed. So you can always ask that. It is free if you have low income parties in your case. And then another, we've mentioned this too, but when parents are deceased, provide all possible evidence, even if only via affidavits from multiple family members. Okay, this is kind of taking us off topic, but I have one slide dedicated to short-term guardianships. We went through this in detail if any of you were at the last presentation that we did, but a short-term guardianship is one of the forms of guardianship in Illinois. This is a private party document. It's completely free. It's like a power of attorney, but it's specifically for the care of children. It does not require people to go to court. There's no cost. It does not need to be notarized. This is a form that allows any parent, but particularly for our purposes, undocumented parents, to assign a caretaker for their children in case of emergencies. So it allows me to say that if I am detained or deported, for example, I'd like to leave my children with my sister, and I'm going to appoint her as the short-term guardian of my children. It takes effect upon a specified event. So if I fill out this form today, it does not take effect today. If I write it to take effect on the day that I'm detained or deported, that's when it's going to start. And they can be valid for up to 1 year. So the year of validity is not from today, it's from the time when that specified event takes place. But it's important to know that these forms can't be used to avoid the other parent. So in that situation, if I want to appoint my sister as like the emergency guardian or the short-term guardian of my children, the father of those children, if he's out there somewhere, his parental rights are going to trump that short-term guardianship. So I cannot use this form to keep the kids away from their dad. I would need to have some other type of order from a state court, like an order of protection or a custody order if that were a concern for me. Either parent can revoke a short-term guardianship form. So even if I fill it out, the father of the children can revoke that form if he's not in agreement. So that's an important thing to know. If you have any people in your community who want to fill out this form or who want to talk to someone about this, CVLS can do this. My direct number is the number at the bottom of the screen. People can call me. It's a free service that we're providing of lots of volunteers willing to help clients do these. And we can also give presentations. So not at the moment, but we've been doing a lot of these community presentations with SWAP and Centro Romero and other community service organizations. If you're interested in that, just feel free to reach out to me. And then guardianship frequently asked questions. So these are a few things that Hillary suggested that I include, that some questions that she might see frequently, some steps to filing. So I think we've been through a lot of this, but preparing the documents, e-filing, sending notice to appropriate parties. And then for a guardianship case, for SIJ, you should be looking at one court date if everything is perfectly in order, especially if you have written consents from the parents and you have any like death certificates and proof that that the parents are deceased, for example. You might be looking at one court date and you're done. Maybe 2 court dates or 3 court dates if issues arise. Like in that one case that I mentioned, one of the parents was deceased, but the court wanted to see more proof of that. So we had to continue the case once so that the family could obtain that photo of the grave site, for example. So something like that might come up, but relatively short in duration with regard to the predicate order aspect. Normally the child must be in the guardian's custody. So Hillary said that sometimes people ask, do I need to have the child in my physical custody to file a guardianship case? The answer is technically no. So the Probate Act is kind of weird in its language. It says that either the parents need to consent to the guardianship, or you need to be able to prove that the parents have voluntarily relinquished physical custody of the minor. So that is sort of unusual language, but it basically means to say that they have freely or voluntarily given up, their physical custody rights over the kid. So essentially that the kid is living with someone else. Technically, the statute does not say you must have physical custody over a child to file a guardianship petition, but one could interpret it that way, because if the parents have voluntarily relinquished physical custody of the kid, then hopefully that child is with you. So that's why I say normally, but technically the law doesn't require it. So there could be limited circumstances where I might file for guardianship of a child who is not living with me right now, but the court is going to want to see a really good reason for that. Otherwise, the court is going to be concerned about, well, who are you? Does this child know you? Why are you petitioning for a kid who's not even living with you? Is this kind of a money grab, for a child who might be receiving Social Security or other benefits? Why, it's an unusual circumstance, right? So the court is really going to look at that with some scrutiny, but technically it could be done. And then the same thing for the next bullet point. So I get this a lot. Does the court allow guardianship to be entered when the parent is living in the same home as the petitioner? So say I live with my sister and I want to grant guardianship of my child to my sister, but we all live together. Will the court allow that? And again, the court will not, the statute does not say that that's not possible. The statute says that if parents consent, then a guardianship can be entered, but the court is really going to look at that with scrutiny also. They're going to want to know, why do you need a guardianship if the parent is living in the same home? Because this parent has not voluntarily relinquished physical custody of the child. So why is the parent agreeing to this? Is this like for educational purposes because the guardian makes less money, or and it doesn't want their money reflected on a college application, or the judge is going to want to see some really good reason for that being entered. And 2 of the most common that we see are if a parent is on active military duty and they expect that they could be deployed at any given time. That's a good reason why you might want someone who lives in your home to have guardianship of your kid. Or if you have a parent who's disabled and who lives in the home, and the guardian of the child is also the caretaker for that adult, and that parent is unable to parent their own kid. It might be a good reason, but otherwise we don't see that happen very much. And then the court will require some form of ID from each party. Hillary wanted or sees this question a lot about what types of ID. For the kids, ideally, the court is going to want a birth certificate. For US born kids especially, the court will require that birth certificate. We realize that for immigrant families, in some cases, those birth certificates are not available or cannot be obtained easily. And so the court is going to want to see some sort of proof that that person is who they say they are, especially for adults. It doesn't have to be a US ID. It could be matricula or whatever the person might have that's some sort of official form of ID.
Can the adult show a birth certificate if they don't have a photo ID?
I haven't seen that happen. Most adults have some kind of ID, but I think so. I suspect the court would accept that. Is there a question? Hillary, do you see this question?
The dissent in Perez v. Cuccinelli, when USCIS might scrutinize the state court judgment. So we're going to talk about the immigration process right after this. I think we're going to take a quick break and then we'll go into the immigration piece of it. But yeah, if you want to disseminate that decision, please feel free.
Okay. And then there's another question. This is a very good question. If there's a pending DCFS investigation, can guardianship still be a process for the minors? The real answer to that question is no, that if there is an active DCFS investigation still pending, guardianship should not be filed unless it's a situation where DCFS is recommending that the guardian file in probate. And sometimes, you know, a DCFS caseworker will help the family through that process, will come to court with the family, will help them prepare those guardianship cases. But if there's an active DCFS investigation still going on and placement of that child is still to be determined, a guardianship case cannot be initiated because DCFS's decisions are going to trump what might happen in the probate court. So the next slide is communication with the immigration attorney. This is super important in all predicate order cases, that even if you have, you know, the state court aspect down pat, or even if you're an experienced divorce or guardianship attorney, it's super important to have constant communication and review of your documents with an immigration attorney to make sure that your language is mirroring what immigration is going to need for that final application and USCIS process. So you want to make sure that that Hillary or whoever experienced in this on the immigration side has reviewed anything that gets filed or entered in the state court.
So I think we've basically talked about this final hearing, right?
Yeah, so we mentioned that in domestic relations, you're going to have to request that final hearing with a motion. You're going to have to say like, okay, court, I'm ready to have my final hearing. In probate, that just is going to be scheduled for you. So you won't need to do that. You'll already have a court date. And you can assume that that next court date is going to, in an uncontested case, is going to be your final hearing date. Larry, do you have anything to add on that?
I don't think so. I think we've talked quite a bit about, I just want to be a little bit cognizant of time because we're going to end at noon.
Right.
But these are in your materials. This Inri Nina L case, I believe, is in there. If not, we can send it around. This Public Act is the new law we talked about. And there's also, NIJC has a memo of law that we provided in your materials as well that just explains sort of state court judges' authority and obligation to enter these findings. So if there are any additional samples, feel free to reach out.
Okay, great. And this is just more detailed information about that final hearing in domestic relations, or that prove up date, which is the term that they use in domestic relations. You're going to need to prepare your client to testify. You as the attorney will have the opportunity to ask questions of the petitioner in open court on the record. And so you're going to want to go through those questions ahead of time and make sure that your client is prepared to answer those questions. The judge may also ask questions in both venues and probably will, especially in guardianship where you don't have this more formal prove up process. The judge may have some questions of her own or his own. And again, young children, usually not in domestic relations or probate, but kids over 14 can wait in the hallway, and in some cases may be asked to come and actually testify. And then if all goes well, the judge will enter the final judgment with SIJ findings you've drafted. Bring multiple copies of that final order. The court is going to want the original. You're going to need a copy that gets certified for the petitioner or the guardian. You're going to want one for yourself. And that is important for guardianship cases, especially. You're going to want to send them down to the clerk's office to get those orders certified on that same day. And in a guardianship proceeding, the court will enter what are called letters of office, which is another piece of paper certifying that this person is the court-appointed guardian of the minor. Pretty important to go and get those on that day. You can get letters of office issued, which is what they call it, or obtain those letters of office from the clerk's office on that same day. But otherwise, you're going to have to wait until the file gets back to the clerk's office. So best to just go ahead and get all of that done, get everything certified with a court stamp, and get those letters of office while you're there. So if you have a guardianship case, ideally your guardian will leave with 2 official documents that prove guardianship, an order and letters of office. Okay, I'm this is you or me?
Oh, this is just something I added at the end, just a quick update. As you know, we have an outbreak. So courts are mostly closed. Cook County courts are suspended except for emergencies until April 15th. Here are some cases that can be included as emergencies. New cases can still be e-filed, at least here. And if you want to look at a court that's in a county outside of Cook, you can go to the illinoiscourts.gov webpage. Those courts are mostly doing their individual orders for the individual counties that they're in. But a lot of these cases will probably be on hold absent some kind of emergency, at least for a couple of months. And I would like to make sure that we get a chance to take a quick break because we need to end at noon. So can we say maybe like 7 minutes? 10 minutes, and then we'll come back and speed through the immigration side of things and see if there's questions before we have to end.
Yeah, just one additional thing to mention on this court closure. If you have an SIJ case that needs to be filed as a quote unquote emergency because the child is turning 18, Hillary and I talked with a pro bono attorney about something like this recently. I don't know whether the court will consider that an emergency, but I think it's worth trying because this is our only chance to get it right. So in my opinion, that's kind of an emergency, and the judge will either do it or she won't. But they've got a rotating schedule of judges, and I actually have a copy of that, at least for the current time period until April 15th. So if you need to file an SIJ case between now and whenever the courts reopen, you might want to consult with me to see what date you can get, because if you e-file, you can choose from a drop-down menu what date you want, and we might want to look at who is going to be on the bench that day because it could make a difference. That's all I've got.
Okay, let's take a quick break if that's okay and come back at 11:37. That sound good?
Okay.
Yeah, great. Thank you.
Should we get started again? I believe we are at 11:37.
Sure.
Okay, so hope everyone is back. We're just gonna go ahead and get started because we've got only about 20 minutes or so to get through the rest of it. I just wanna make sure there's some time for questions. So the immigration process for SIJS starts after you get the predicate order, right? As the immigration attorney, you should have been hopefully working with the family law attorney and actively involved in the process to make sure that the language in this final custody or guardianship order is going to be sufficient for immigration purposes throughout the whole process before you start the process of filing the immigration petition. That being said, we're going to go through what that process is like and what considerations you will be looking at as the immigration attorney. So SIJS petitions are filed on Form I-360, just like VAWA petitions, and they're self-petitions, just like VAWA petitions. So in the immigration aspect of this case, the child will be the one filing the immigration petition. The minimum required evidence to an SIJS petition is the I-360 form with your G28, the predicate order with the SIJS findings, and a copy of the child's birth certificate with a translation. If you have a child who's non-accompanied minor, I'll often include a copy of the ORR verification of release just to show that the child was a designated unaccompanied minor. I don't include anything else in my initial filings. This is not one where I do a huge legal memo. I don't provide any other evidence regarding the child's abuse, abandonment, or neglect. I don't do affidavits because that all technically is not USCIS's business, right? USCIS is just there to review what the juvenile court has already heard and made a determination on. USCIS isn't supposed to look behind the juvenile court order, so it was the juvenile court that made these determinations, and we're just showing that that is the case here. As far as filing the I-360, like I think we said previously, best practice is to try to file that case immediately as soon as you get the custody order, and preferably before the child turns 18. Once the case is filed, there are age out protections, right? So if the child turns 18 and their I-360 has not yet been decided on by USCIS, that's fine. They're still protected. If they, and we'll talk about these delays, if the child turns 18 or even turns 21 and their adjustment application hasn't been adjudicated, technically they still should be protected. That's getting to be a bigger question now that these delays are getting longer. The TVPRA provides these age out protections. This is the site for it. The TVPRA also requires that I-360s be adjudicated within 180 days. Up until recently, this definitely wasn't happening. In the last few years, USCIS was taking like a year and a half to adjudicate these. What I'm seeing now is that they're once again adjudicating at least the I-360 piece of these cases pretty quickly. I've gotten a couple responses within a couple of months of filing. If I can make forward again. Nope. Nope. Oh, there we go. All right. All right, so USCIS guidance. So USCIS has the final say to approve or deny a petition, but USCIS is not supposed to be taking over the role of the juvenile court. So if USCIS doesn't like the evidence, if they have suspicions about whether the child was in fact abused, abandoned, or neglected, that's sort of USCIS supplanting their authority for the authority of the juvenile court. They should not be doing that. We were getting requests for evidence in the past, mainly regarding whether the juvenile court entered citations to state law in those final orders. So remember, we said the final order needs to include findings that the child's reunification was not viable with one or both parents, that the reunification was not viable due to abuse, abandonment, or neglect, and that it wasn't in the child's best interest to return. We emphasized those citations to the appropriate state law definitions of abuse, abandonment, or neglect had to be in that order, because USCIS has been sending those back to us saying the state court didn't cite to the state law regarding abuse, abandonment, or neglect. So we've been doing that as a practice, even though state courts presumably know what their own law is, and it's not part of their typical practice to cite to the law that they're using to make those determinations. We're just asking them to do it anyway because it's easier than fighting with USCIS about it for the most part. The SIJS regulations were reopened last fall, and it seems like there's going to be a new focus on motive. That's pretty concerning because there has, to some extent, always been sort of this view by USCIS that if the child's only motive in seeking this predicate order is to get immigration status, that's somehow not good. I've always found that bizarre and confusing because the whole point of getting immigration status is to provide that vulnerable child stability and the ability to stay with a parent or guardian who they're living with. So it's strange to me that they would say this benefit exists, but you shouldn't apply for it because you want it. You should apply for it for some other reason. That being said, they are starting to focus on that. And so it might be good to think about before you file a case what the other non-immigration related benefits to the child are for filing that case, right? Including, you know, all of the benefits that typically come with a formal custody order. It's in English. It provides clarity to schools, to medical responders. It provides clarity to all kinds of state government services and agencies, especially in a time of sort of uncertain immigration status and immigration enforcement. If a parent is or guardian is suddenly, God forbid, detained or deported, that order will provide some clarity as to who gets to make decisions regarding that child.
Right. And that's especially true for a guardianship case where a child is living with a non-parent, because in the absence of that order, that person has no decision-making authority over that kid.
Okay, so we want to avoid language that suggests that they're seeking the state court order only to get immigration status. In general, we want to avoid language in the state court order, you know, at all regarding why they're there besides just the facts necessary to file a custody petition. But mixed motives are okay, right? So a child may be seeking this order to get lawful immigration status and all of the other benefits to the custody order. What the guidance that we received last fall regarding the reopened regulations was that they actually specifically want to see what the court is granting some relief from abuse, neglect, or abandonment. Usually a custody determination is that relief, but if there is any other specific action the court can take regarding that abuse or neglect, that might be helpful to include that language. Let me see if I can move this again. There we go. Okay, so USCIS guidance is also talking about the factual basis. So the state court, the final state court order has to include the evidence of the factual basis. So previously, for many years, these state court orders like literally parroted the language of the statute. It said, child reunification with one or both parents is not viable due to abuse, abandonment, or neglect. That's not sufficient. Now you have to say which parent it is, which one it is, and what the facts supporting that are. So child's reunification with her father is not viable due to abandonment. Here's why he has abandoned her. That is basically what's considered sufficient these days in USCIS. And in addition to those supporting facts, you actually need to cite to the Illinois definition of abandonment that you're using in that situation. So we talked briefly about paternity. That's a tricky one, right? Like if you're assessing a child for eligibility for SIJS and it's father who has done the abusing or abandoning or neglecting and father's name is not on the birth certificate, paternity has to be established. That gets tricky in Illinois courts if a court decides they don't have jurisdiction to establish paternity. Many courts will just go ahead and establish paternity if mom goes in and testifies credibly that she was in a sexual relationship with dad from X date to X date that resulted in the birth of a child. That's done every day, to my understanding, in many parentage and child support cases. But because these cases are a bit unusual, there might be some hesitance on the part of the judge to enter those orders. Even if a judge is unwilling to specifically establish paternity, if they're able to refer to the alleged father by name, that's helpful. And you should still be able to get a custody order, even if the court will not specifically establish paternity. But I guess reach out to us if there are issues in this matter. There are some ways for a court to take jurisdiction over a father who is not currently in the state of Illinois. There's a provision in the Interstate Family Support Act that governs certain child support cases that says if the child, for example, resides in the state of Illinois as a result of the acts or directives of a parent, then a court may take jurisdiction over that person. I think that's one of our stronger arguments in many SIJ situations, is that the child is here because the child was abandoned. If father hadn't abandoned the child wouldn't have had to flee to the United States to find mom, etc. But looking carefully at the facts of your case will be helpful in that situation. I think there's other situations where we may just want to appeal the issue with USCIS, right? We can imagine scenarios in which perhaps the child is a product of rape. That's very clearly, father has abandoned the child in that situation. Father is not on the birth certificate. Should that vulnerable child then not be eligible for SIJS simply because father's name is not on the birth certificate? But definitely reach out to us if you have these kind of unique situations regarding paternity, and we can kind of strategize. So USCIS guidance number 4 is the best interest requirement. So that third requirement. So reunification not viable due to abuse, abandonment, or neglect, and that it's not in the child's best interest to return to their home country. USCIS is literal about this. They will not accept it is in the child's best interest to stay here. They really literally need to see it is not in the child's best interest to return. I don't know why. That's what they require. They've also recently been sending RFEs saying they want to see that there's no other appropriate placement in the home country. That is a bit beyond the pale, I think, from the perspective of a juvenile court. Like, it is not a juvenile court's job when making a best interest determination of a child before it to search the world to see if there would be some other placement that would be appropriate, right? They're basing their determinations on the facts before them, the people before them, and the child before them. That being said, if your parent or guardian can say, they don't have another appropriate guardian in home country and here's why, and you can include that in the final order, hopefully that is enough for USCIS. But it is a bit of a bizarre requirement that they're trying to say, well, a juvenile court should do some sort of investigation of all possible other placements in other countries. Okay. So
I have one other thing to add, Hillary, about while Hillary mentioned that it is really important to cite state law requirements in the petition and in your order, not appropriate to cite to immigration law, right? So we've seen some orders that say, this language complies with INA, whatever. You should not be referencing any immigration law in your state court predicate order.
Correct. And that is why, so we have a sample memo that we've circulated. I think a memorandum of law is a helpful way to explain what's going on in this case and the interaction of state and federal law to a judge without having it just all laid out in the final order, which then USCIS may decide they don't like. So filing a separate memo of law may be helpful in this type of case so that you can really explain to the judge, okay, here's the federal law, here's the state law, here's how they interact, here's why we want you to do this, without, you know, having that whole step-by-step put in your final order. So your I-360 is filed and then it gets approved. Now what happens? So I've been mentioning these delays, right? These are for kids from specific countries, Guatemala, El Salvador, and Honduras, as well as Mexico. Kids who are not from one of those 4 countries should at this point be eligible to file their I-360 and their I-485 together as a one-stop and will not be subject to the same type of delays as kids from those 4 countries. So that would just be a standard processing times case, and you would wait for either an interview on your I-485 or approval or an RFE or whatever it is. For kids who are from the Northern Triangle of Central America and from Mexico, you will need to file these separately. So first you will file your I-360, and once that is approved, you will then be eligible to apply for lawful permanent residence. And an I-360 approved all by itself doesn't really actually do much. SIJS, so it means you're an approved special immigrant juvenile, which is great. All that means is you are then on a path to get your green card. It doesn't actually give you a work permit. It doesn't give you a permanent lawful status in the United States. So for those of you who may do family-based immigration, it's sort of like an approved I-130 in that sense. Like, it means you're eligible to apply, but it doesn't actually give you those benefits. So in order to then determine whether you can file your Form I-485, you have to look at the visa bulletin, which is the bulletin that the State Department issues each month, showing how many visas are available in each category worldwide. Currently in the visa bulletin, there are 2 types of charts. One's called dates for filing and one's called final action dates. The dates for filing says when you're even allowed to file your Form I-485. The final action date means when USCIS anticipates actually working on your application for lawful permanent residence. So you'll want to check both of those, and I have an example here. An important thing about this is that a work permit is only available once you have your Form I-485 on file. That means we have many kids from the Northern Triangle who are sitting here. They are approved special immigrant juveniles, but because they are subjected to years-long delays based on the visa bulletin, they cannot get work permits in the meantime. They're just kind of sitting there. And those kids are getting older and older. They're at an age where they want to work, where they may need to work to support their families, and it's causing a lot of problems. And from what we can tell, there just isn't another option to do it unless they're eligible for some other form of relief that could get them a work permit.
Hillary, how do you know when your time is up to be able to file your I-485? Is it one of those like categories that become current, or how do you find? Oh, there you go. Okay. Yep.
So this is a screenshot of the April 2020 visa bulletin. So this is the final action date. So actually I'm going to go to the dates for filing. So dates for filing in the visa bulletin. So SIJS visas are taken from the employment-based 4th preference category. Don't know why, but that's where you're going to be looking. So if you look at this chart under the 4th preference category, everything is current except for El Salvador, Guatemala, and Honduras. That means right now, actually, kids who are from Mexico can file their I-360s and their I-485s at the same time. They'll be subject to a delay in actually processing their I-485s, but they can file the I-360 and I-485 together, meaning they can also file for a work permit right now. So very lucky for kids pretty much from every country except these 3 from the Northern Triangle. These 3 countries from the Northern Triangle are the priority date. The date for filing, your priority date must be prior to August 15th of 2016. That means you have to have filed your I-360 prior to August of 2016 in order to be now eligible to request your green card. If this were a typical processing time, this would mean maybe there'd be about 4.5 years before a visa would be available to you. However, the visa bulletin has been at 2016 since 2016. They have not really moved much in that period of time. And so I was speaking with a national expert the other day about SIJS, and she's looking at this more like an 8 to 10 year wait before this moves forward to kids who are filing their I-360s right now. So it's a significant wait time before you're even eligible to file your Form I-485. Okay, let me see. There's a question. If a child is only 14 but is otherwise eligible to one stop, would you file a work permit? I think that's up to you and the child. I'd be inclined to offer it to them as an option because it's great to have that government issued photo ID. And because if, you know, things get more delayed, they may lose that option later, right? So at least the category for Mexico has been kind of back and forth about whether it's current or not. On the other hand, they may not want to, they may not be prepared to file that. It's kind of up to them. I filed work permits actually for very young children because it's helpful for their parents. Their parents wanted them to have that form of ID. Okay, just going back really quickly to, oops, the final action dates. So as you can see, the final action dates for the Northern Triangle are about a month prior to the dates for filing, meaning USCIS is only now getting to processing I-485 applications that were filed for kids who filed before July 15th of 2016, and final action date for Mexico is 2018. So for Mexico, you can file an I-485 right now, but you're looking at maybe a 2-year delay approximately before they actually get to processing it. Does that make sense? I know the visa bulletin gets complicated. Okay, question. What would be the code used on Form I-765? C9 based on, yes, C9 based on pending I-485. That is correct. There's nothing else special that you have to do for an SIJ work permit. Does the minor sign immigration forms? Yes. So if they can, right? A parent has the ability to sign on behalf of a minor under the age of, I believe, 13. If a child is old enough to write their name and they want to write their name, I'll have them sign it. Otherwise, I'll have their parent sign it as their parent, or their legal guardian sign it as their legal guardian on their behalf for very young children. So moving forward, if we can move forward. There we go, adjustment of status. Okay, so special immigrant juveniles are eligible to adjust under 245H. 245A and H. This means that many grounds of inadmissibility are not applicable to special immigrant juveniles. A lot of them are just exempt entirely, and a lot of them are waivable. So you can check out the regulations and the statute for the long specific paragraph that kind of cross-references other paragraphs in the INA, or you can click this link. The ILRC has an excellent chart summarizing their inadmissibility exceptions. Specifically, what you should know is particularly EWE, public charge, unlawful presence are not applicable to SIJs. So when you file an I-485 for an SIJ, you do not need to file that separate form for public charge. They're not subject to public charge at all. There's other grounds that are waivable. Some of those include prior immigration violations, health, prostitution, and smuggling. Most criminal conviction and terrorism grounds are not waivable. Drug trafficking is not waivable. So when we have a kid who may have some criminal issues, you want to talk to your crim-im experts and see if there's a way to argue that those convictions are do not constitute certain types of convictions, do not constitute CIMTs, and see what other arguments you may come up with. I think really importantly to this is the fact that juvenile adjudications do not constitute convictions for immigration purposes. So if a child is convicted of a juvenile offense, that may go to discretion based on the acts that they committed, but it is not a conviction and therefore is not a criminally based, a conviction-based bar to admissibility. I would also say that, so when I'm filling out an I-485 with a special immigrant juvenile, there's a lot of conduct-based questions, right? They're very broad, they're fishing expeditions. So from our perspective, any act committed by a juvenile, if it couldn't have been prosecuted as a criminal case because they're a juvenile, then the offense itself cannot be classified as a crime. Does that make sense? So when it asks, have you ever committed a crime? If a child is not an attorney, right? So they don't know what the legal definition of what specific crime is. So from that perspective, I would say the child cannot answer that question in the affirmative in most cases. But B, if a child committed an act as a juvenile, that act couldn't have been, an act that could not have been prosecuted as a crime because juvenile adjudications don't constitute convictions. And I think that's another ground to be able to say, nope, we're going to answer that question in the negative. They did not commit a crime because it would have been a juvenile offense. Okay. Adjust under 245A and H. Are they subject to the permanent bar or is it waivable? I think that they are not subject to the permanent bar, but I cannot tell you 100% because that constitutes prior immigration violations. So I would have to look at the specific provisions, but I'm pretty sure that is included in the exemption from prior immigration violations. How am I going backwards? Okay, here we are, adjustment of status. Yeah, so feel free to correct me if I'm wrong, but I am pretty sure that the permanent bar. Does this mean you can't use criminal waivers in the event that the child has a qualifying relative? So I think that that's true. I haven't done an adjustment in so long, to be honest with you, because my cases are so delayed. My understanding is that these, many of these criminal grounds are not waivable, but I have seen some discussions on SIJ listservs about people trying to do 212H waivers. So I could direct you to online resources for that unless Jane or Servan has more solid information about that. So in the meantime, I am going to move to SIJS and removal defense. So what happens if your child is an SIJ, they're facing an extremely long wait time, and in the meantime, they're in removal proceedings? Generally, again, a like COVID-19 update is that who knows what's happening, right? Like immigration courts have suspended most non-detained hearings. We'll be back in operation at some point. It's unclear what that's going to look like after that. Up until now, so far, we have been relatively lucky in Chicago immigration courts because judges have been granting long continuances for these special immigrant juveniles to await eligibility to adjust. They've also been placing kids on the status docket, meaning sort of an automatic long wait, in which you don't have to appear at a master calendar hearing necessarily. You just provide an update that, yes, you're still waiting for eligibility to adjust your status. That being said, one thing to keep in mind is that a special immigrant juvenile may adjust before USCIS or the immigration judge unless their NTA categorizes them as an arriving alien. If that's the case, it's really important if you have an SIJ and removal proceeding to check your charging document, because if it says arriving alien, that means that the immigration judge doesn't have jurisdiction over this child's adjustment application anyway, and you may want to just file a motion to terminate. I have had a couple of motions to terminate granted for kids who are approved SIJs, who are prepared to file their applications before USCIS, and the immigration judge agreed with me and said, yes, I don't have jurisdiction over this, so we're going to go ahead and terminate. Those were for kids who were close to being able to adjust, so it wasn't that they were facing a 10-year wait before filing those applications, and they were before Judge Payton, both of them. So for what it's worth, check your NTA. If it's an arriving alien charge, you may want to try to get the case terminated. Previously, 4 years ago, we were just terminating all of these cases as soon as the I-360s were approved. As you all know, judges' ability to terminate cases at this point has been limited, but we are still occasionally seeing that happen in this circumstance, and we are still in Chicago getting long continuances. Okay, bunch of questions. Let's see. Okay, the criminal waivers, I'm going to refer you to Siobhan. Let's see. Motions to place cases on the status docket are no longer accepted. Is that different for SIJS? So I have kids who are still on the status docket, and those status updates are still being accepted. I haven't filed a motion in the last like 2 months or so to place them on the status docket. So I'm not sure what the most updated status on that is, but the status docket does still exist. Cases are still on it. And we've been using them for SIJs. So Siobhan has provided the policy manual on SIJ adjustment with waivers and bars. Thank you. Okay, so age out protections. Let me just go back really quickly. So as I think I mentioned earlier, an age out protection should apply if the I-360 was timely filed. This is looking a little different now because the child, you know, for example, if a child was about to turn 18 when you filed their I-360 and they're from the Northern Triangle of Central America, they may be almost 28 by the time they're eligible to adjust anyway. So that's a much longer wait time in which we expect them to be protected than what we were previously looking at. What I have here, and again, I would welcome your input, but the age out protections that apply to children before they're able to file the I-485 was in the Paris-Olano settlement. It's currently still in the USCIS policy memo. That's sort of, because it's up to USCIS, feels a little bit more tenuous, but that's sort of what we're depending on right now because there's so many kids in a position where they are not able to file their I-485s before they turn 21 or have been anywhere close to that because they're looking at such a long wait time. And so I guess as far as some practical tips, I have a whole set of cases in which I have kids who are sitting there waiting to be able to file their adjustment. So I'm calling them pretty regularly, maybe quarterly, to check in, to remind them, you have this long pending application, you can't get married until you adjust. Please call me if at any point you have any change in your living circumstance that might make you eligible for some other kind of relief, and please try not to get arrested, right? It's just so much time to wait, and all kinds of things could change. So to adjust as an SIJ, you still have to be unmarried until your adjustment is complete. So I tell my kids, if they're thinking about getting married, call me, because it's possible that that could provide some additional options for them, but I wouldn't want them to make that decision without talking to me. Oh, and we are over time. Sorry about that. So I think this is the last one. Elsewhere in the country, SIJs are sometimes ordered removed. I've been seeing that on listservs. There are some additional arguments that folks are talking about online, including the fact that an SIJS application has been approved means that USCIS has approved the finding that it's not in the child's best interest to return to their home country, right? So it's a bit of cognitive dissonance to be able to say then that that child can be ordered removed if the whole basis of this is that they should not be returned. Unlike U visas, where we had previously been seeing folks waiting for a long time to get ordered removed, SIJs can't apply from their home country. So if someone's SIJ has been approved and they're ordered removed, that's kind of it. You no longer are physically present in the United States, so you're not eligible to just wait it out in your home country and come back in. Finally, approved SIJ means that you have been paroled in, so you should not be, well, A, you should not be needing to consular process, but B, Clinic has a really good sample motion to terminate, arguing essentially that the charges in the NTA can't be sustained because if your SIJ has been approved, you've been paroled in, and therefore you're not present without admission or parole. I think check out this resource, but I think their recommendation is not to file that unless absolutely necessary, because it's just it's a longer shot of an argument. Okay, I think that is everything. Do we have additional questions or concerns? I know that we're a bit over time.
I had a quick question that's not technically about this, but do you have a sense of how long things are going to get continued for people who had court dates during this time?
Oh, like due to the coronavirus?
So I had that family with a kid who's probably SIJ eligible contact me, and he was supposed to have his case up on the 31st.
Of this month?
Yeah. Do you have any sense of how long the court is going to kick those cases?
So for right now, I think they're just suspended through April 10th. But I'm assuming, like, we'll get more updates from EOIR and from the Department of Justice and from our local AILA chapter based on what it's looking like. I'm assuming that will be continued longer, but if they have a court date that's past April 10th, then they need to just keep checking in to make sure that they don't need to show up.
Okay. Thanks.
All right, well, thank you all so much. And yeah, let us know if you have additional questions, and please feel free to use these documents and resources freely.
Thanks, everyone.
Thanks so much, Rebecca and
Thanks.
Hillary. Take care.
Bye.
Bye.